You're watching the legal breakdown. So, Glenn, we have kind of a surprising one here. The Trump team has filed a motion to hold Jack Smith in contempt. Is this something that we should be worried about?
No, I mean, this may be one for the record books because it's one of the most frivolous. It's just a downright silly motion, but let me set it up. So as we know, this case is now in the appellate court, the DC Federal Circuit Court of Appeals on this, harebrained assertion that Donald Trump is a king. He has absolute immunity from prosecution and he can commit any and all crimes he wants while in the office of the presidency. The appellate court has that right now. What does that mean? While the appellate court has it, while they're taking time to decide it, the trial court, that is Judge Tanya Chutkan, who is presiding over Donald Trump's election interference case for trying to overturn the results of the 2020 presidential election, nothing can be done in the trial court. Basically, everything is put on hold while the appellate court has it until the appellate court resolves the issue. So during this sort of downtime, Jack Smith has done a couple of things. One, he continues to give the defense attorneys, Trump's defense team, what's called discovery, evidence, continues to provide it on the belief that, look, you're going to want to have this evidence sooner rather than later because eventually you're going to trial. So the more time you spend with the evidence, the better prepared your client will be when the trial date ultimately rolls around. So Jack Smith and his prosecutors have been giving additional discovery to the Trump defense team. They filed a motion, what's called a motion in limine, asking the judge to decide what arguments Trump's team can make and what arguments they can't make once the case goes to trial. But there's no requirement for the Trump defense team to respond to that motion during this downtime. And the third thing Jack Smith's team did is they provided the defense what's called an exhibit list, which is nothing more than a list that sets out, here are the items of evidence we might introduce to trial, and here are the numbers we are assigning to those items of evidence. That's it. This so outraged and incensed Donald Trump's defense team that they filed a motion to hold Jack Smith and company in contempt, order them to stop giving us stuff. And by the way, Judge, we want money sanctions. I mean, this is just downright silly.
Right. And by the way, if the question of immunity is granted in Donald Trump's favor, all of this will be moot anyway, so it won't matter. So either this moves forward because it's going to move forward anyway, or it's all just moot. And so, like, what's the difference?
Exactly. So, but what they are contending is, listen, while the case is in the appellate court and while we're in this sort of downtime posture, we shouldn't have to do anything. We shouldn't have to work to prepare our defense. But here's the thing, Brian, because, Trump's lawyers are forever taking on the tone and tenor of their client, Donald Trump. Let me just read you one sentence that they drop in, a court filing. And this kind of thing is so unbefitting of a court filing. Here's the kind of stuff they say in this motion. They say the prosecutors have an unlawful goal. Unstated but obvious is the prosecutor's desperate effort to harass President Trump and prevent his likely victory in the 2024 presidential election. These defense attorneys are actually asserting that there is no legal case here. Donald Trump has done nothing wrong. He shouldn't be prosecuted. Jack Smith and his team are using this prosecution as a ruse to stop him from being elected president again. I mean, that stuff is so unbefitting to a legal brief that it's hard to find words.
Yeah. Glenn, we've had these legal breakdown episodes for weeks covering the minutia of these trials. Is the sheer volume of motions and delay tactics normal, or is this especially unusual?
Nothing normal about the way this case is proceeding. Sometimes the defense attorneys will try to push trial dates farther out into the future. There's a rule of thumb that I think prosecutors and criminal litigators generally have. Prosecutors want to go to trial yesterday. Defense attorneys want to go to trial tomorrow. And the judge has to kind of split the baby and set the trial date. Why do I say that? Because time is always of the essence for prosecutors. Why? Because witnesses' memories fade. Sometimes evidence can get misplaced or go missing. And we need to protect
You
the
could even have
community. So we want
witnesses
to
who
try.
die, for example.
I have had that. I had a murder case where there was one eyewitness, Brian, and he died unexpectedly prior to trial. I had to dismiss the case. I felt terrible for the witness and his family. I felt terrible for the victim and their family. I felt terrible for the community because somebody who was pending trial in a murder case gets sprung back out into the community. So prosecutors always want to go to trial yesterday. Defense attorneys, time is their friend. Ordinarily, they want witnesses' memories to fade. They want evidence to go missing. They want the case to grow stale and cold, and they think people might, care less about it if it's set well off into the future. So, but the kind of extraordinary efforts that Donald Trump's lawyers go, listen, Donald Trump's lead attorney in this case, John Lauro, stood up in court. I know because I was in the courtroom at the time and told Judge Chutkan, we don't think this case should go to trial before 2026. And I'll tell you, Judge Chutkan got a little bit animated at that point, and she said, this trial will not yield to an election cycle. So listen, it's no secret the game that Trump's lawyers are playing, and there's nothing usual about the way they're playing it.
So then, is there a point at which the frivolity of these motions, like this one, for example, by the Trump team trying to hold Jack Smith in contempt, can actually trigger sanctions or a line in the sand by the judge?
In theory, yes. In practice, no. The last thing a court ever wants to do is chill a defense attorney from filing any and all motions they think might have even the slightest bit of merit, even the slightest chance of winning. And sometimes, Brian, frankly, defense attorneys will file what they know are losing motions. Why? Because they want to retain their right to argue that same issue on appeal. And if they don't file that motion and litigate it and have the judge rule against them, then they have waived it. They're not permitted to raise it on appeal and argue it on appeal. So it is almost never the case that in criminal litigation, unlike civil litigation, a judge will order a defense attorney or a defense team to just stop filing these darn frivolous motions. What will happen is the judge will just summarily deny frivolous motion after frivolous motion.
Okay, so at this point, while we await the Supreme Court's eventual ruling on the issue of Trump's immunity, because right now you mentioned that it's in the appeals court, but I presume that ultimately this issue will be litigated by the Supreme Court. Does it already seem like the March 4th trial date in Washington, D.C. will have to be pushed back? And if so, what is the best and worst case scenario for a new trial date?
Yeah, great question. I don't think all bets are off that the March 4 trial date might stick. I think it still could stick. Here's why I say that. Right now, the case is in the DC Federal Circuit Court of Appeals, and it's scheduled for oral argument on January 9. Next week, I'll be in the courtroom watching the oral arguments. I predict, I predict things at my own peril, but I predict the appellate court will resolve it very quickly. Like we may have an opinion within a matter of days or perhaps a week. And then if the Supreme Court is an honest broker of the law. Now, the word if is doing some really heavy lifting in that sentence. But if the Supreme Court is an honest broker of the law, they will refuse to grant review of the absolute immunity, a president is king issue, because there's no law supporting that nonsensical claim. So it could be that once the appellate court rules, the Supreme Court will say, we are not taking this case for review. What that means is it is instantly back on track to go to trial. If all of that happens in January, maybe by late January, there's nothing to say that that March 4 trial date can't stick. It can stick. I do think it gets less likely to stick over time. And I do think all scheduling bets are off if the Supreme Court decides to take the case up on review, because then that's going to take some time to work its way through the system. But if we think back to the precedent of Richard Nixon in 1974, we have seen the Supreme Court actually take these matters and act within a matter of weeks. So still, outside possibility, even if the Supreme Court accepts it for review, that we could be going to trial in March.
Okay. And finally, let's finish off with this. When will we be done with these pretrial motions once and for all, and can actually prepare to get into the meat of the trial here?
Once the case is back in a trial posture, so the appeals are done, Judge Chutkan has it again, then I think the case will move to trial pretty promptly. There will still be some routine motions that will need to be litigated and resolved. We'll need to go through jury selection. That will probably take about a week or so. But once Judge Chutkan has it back, even if we're now kind of moving the March trial date down the road a little, there's no reason that once she has it back, the case can't be ready to go to trial within 4 weeks, 6 weeks, 8 weeks, around that time frame.
Okay, well, obviously we'll stay on top of all of this, including Glenn, when you're in the courtroom there and following what's happening on January 9th. So for anybody watching right now, if you want to follow along with all of this stuff, please make sure to subscribe. The links are right here on the screen. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.